Hello, this is the Jones Chase A to Z of employment law, and this is the letter O for occupational health. So when's occupational health relevant in an employment relationship? Well, there are three particular occasions. The first is before the employment relationship starts. The second is during the employment relationship itself. And the third is if there is any litigation between the employee or ex-employee and the employer, and it has a medical element to that litigation. So let's think about before the employment starts. And this may be whether health or someone's physical ability is a relevant factor for the job, or as a requirement for acquiring certain benefits, such as a health insurance matter. You may want to involve occupational health to assess the medical situation of the prospective employee. And this can be done at offer stage to the individual to whom you're making an offer. And it's to limit the risk of employing someone who may be or may become unable to do the work that you're recruiting for because of ill health, or in order to determine that insurance scheme membership. And then during employment, occupational health is relevant, and ACAS provides a very helpful list in their guidelines in relation to medical evidence. And that list during employment provided by ACAS includes when an employee is struggling with their physical or mental health, to make the right reasonable adjustments for disabled people at work, when an employee has been off sick for a long time or is returning to work after a period of sickness absence, an occupational health report is relevant at that time in order to assist in deciding how and when that individual should return. And then to reduce the amount of time people need off sick, because attending occupational health can make a more valid assessment as to the period of time of absence. And then to keep within other health and safety regulations to ensure that you're abiding by the Health and Safety at Work Act. And then to control risks to mental health, such as too much pressure at work, or if there's bullying or harassment alleged at work. Other points beyond the ACAS list would include any concerns that you would have over whether an employee off sick is genuinely sick, or maybe in order to determine that eligibility for PHI cover and or medical insurance cover. So there are many elements within an employment relationship where occupational health's input and their medical assessment on the individual and or the role is essential. And then the final period, when I described occupational health will it be relevant in an employment relationship, is in the course of litigation. And litigation can occur whilst an individual is an employee, but also when an individual is an ex-employee and is bringing a claim against their ex-employer. And that claim could be for disability discrimination, and occupational health will be there to assist in determining whether it is a disability. Obviously, the ultimate decision is the judge, but is that of the judge, but occupational health can be there to determine the disability and what that disability is. And it can also be there to give evidence on behalf of the company in any litigious matter. Occupational health also in litigation can be useful for capability dismissals, in that they will be able to assess the individual's ability to carry on doing a role in light of their medical position. So what does an occupational health report have beyond a GP report? Well, one of the things that occupational health do is assess the job itself and then the individual's ability to do the job and their health in relation to doing that job. And that's beyond the GP report, which just refers to the individual's health itself. I mentioned earlier on about assessing whether somebody is genuinely ill or not, and that is a very helpful situation in which you can involve occupational health if indeed you believe that the individual is not ill. I also suggest that you include in your list of disciplinary matters the fact that someone is pretending to be ill and claiming sick pay, or is off sick pretending to be ill, should be a matter of misconduct, as I say, in your disciplinary list. And then I would also suggest that you include in your contracts of employment the right for you to refer the individual to occupational health to have a medical assessment when you as the employer deem that that is a reasonable time to suggest such an assessment. So the final thing I want you to have a regard to is that the occupational health view is just that. It is a medical view in an employment relationship. Ultimately, the decision whether you take any action as a result of the employee's health is down to the employer, and it's your decision based upon medical evidence but also other evidence surrounding the matter. So please keep that in mind. Finally, I'm going to refer you to a case of Gallup and Newport City Council. It's a Court of Appeal case, and it held the employer was wrong to have ultimately, unthinkingly followed an occupational health advisor's opinion that an employee was not disabled. The responsible employer must ultimately apply its own mind to the test for deciding whether the employee is disabled under the discrimination legislation. In this particular case, the Gallup and Newport City Council case, the condition was stress. Started in 2004, 4 years of occupational health sessions and reviews and periods of work, and occupational health always said it was not a disability, and the employer relied upon this to dismiss. And the judge in the case, and it was a case where the employee alleged unfair dismissal and disability discrimination when he was ultimately dismissed. The employer argued it's not a disability because we relied upon occupational health, and the judge stated in that case, you have unthinkingly just had regard to the medical opinion on this without considering all other circumstances which you, the employer, ought to have realised that this is a disability. So I am going to leave you with that point, to not act unthinkingly in relation to medical conditions of employees. I've gone slightly over my 5 minutes, but I hope you've stuck with it, and see you next time.